Sir, I really like reading Constitution and procedural laws as well.
Very good. CPC आ गया है ना?
Yes. CPC, CRPC, evidence.
Res judicata के principles
Yes, sir.
देखे होंगे हम.
Yes, sir. So, sir, it is provided under Section 11 of Civil Procedure Code, and it says that no court shall institute any suit or proceeding. The matter in which is directly or substantially an issue has already been decided by a competent court. So, such matters shall not be taken up again.
Alright. So, what is cause of action, Ms. Payal?
Sir, cause of action essentially is the bundle of facts or the disputed facts on the basis of which issues arise and adjudication is made.
Issues is right that one party asserts that and other party
denies that fact.
Okay.
Yes.
And what do you mean by suit of civil nature?
So, suit of civil nature is essentially those suits in which rights and liabilities of parties are determined. Section 9 of the Civil Procedure Code talks about suit of civil nature, and in determining as to the suit of civil nature, there might be some incidental questions as to caste or political or religious questions, but directly any question of caste or political questions are not suit of civil nature, but incidentally it can be, or whether any office to fee to any office is also attached, then that can also be termed as suit of civil nature.
All right. So what do you mean by precepts?
So the concept of precepts is provided under Section 46 of Civil Procedure Code. It says that whenever the decree has been passed by any court, then the decree holder can apply to another court in which the property of the judgment debtor is there, so that that property is attached and so that the property is not disposed of or damaged. So in order to secure that property, the judgment holder applies to the court to issue precept for the court of another jurisdiction where the property of judgment debtor is there, so as to secure that property.
Can a court execute a decree outside his jurisdiction?
Indeed, sir.
Okay, which provision?
Sir, I believe Section 39 says this.
Okay, so a court can execute a decree outside his jurisdiction, that is what you were saying?
It can transfer, sir, for execution. If suppose the property is outside the jurisdiction, it can transfer its decree to the transferee court where it can.
But he cannot execute.
Sir, I'm not very sure of this.
Okay, all right. Payal, what do you have to say about the reservation? And what do you mean by vertical reservation and horizontal reservation?
Sir, the concept of reservation was brought in by Dr. B.R. Ambedkar during our framing of Constitution, and I believe this is one such provision which definitely helps the underprivileged people to uplift them. However, there has been a series of legislations and judicial pronouncement on the basis of which reservation laws in India are governed. For example, starting with the case of Indra Sohane, which was also called Mandal Commission, where it was said that Section 16(4) should not be read as an exception to Section 16(1). Rather, it should be read in harmony with Section 16(1). Also, Indra Sohane judgment said that the 50% ceiling limit should be retained. However, this was again through 81st Constitutional Amendment, this was relaxed, and now there is no such bar of 50%. Coming to recent days, there have been cases like B.K. Pavitra 2, which was in 2019, or for that matter, M. Nagaraj case, in which it was said that the state government must collect quantifiable data, and these data must be updated on yearly basis so as to see as to whether what caste are still falling under that category and whether they have moved out of that category or not. And recently there was also Maratha quota judgment in which the Supreme Court, Honorable Supreme Court, held that they already fall within the mainstream of the society and there is no need for reservation to them.
Okay, you have omitted to answer one question, that is horizontal and vertical.
Sir, I'm not very sure of this.
Okay. All right. And how you are going to connect Article 14 with Article 21? Is it any connection with it?
Indeed, sir. Sir, in the landmark case of Menaka Gandhi versus Union of India, The Honorable Supreme Court said that there is a connection between all three articles, Article 14, 19 and 21 as golden triangle. So, whenever we talk about Article 14 says equality, and the modern concept of equality as laid down in the case of E.P. Royappa was not abolition exactly, but removal of arbitrariness. So, whatever state action must be there must not be arbitrary. And same as in Article 21, it says that there must be due process of, there must be procedures established by law. However, that process must be fair, equitable, and reasonable. So, we can connect that from there, that whatever law is being made must be fair, non-arbitrary in nature.
All right. So, Payal, what do you understand by the concept of judicial review?
Yes, sir. So the concept of judicial review is that Supreme Courts and even High Courts are bestowed with power to review legislative, executive and even judicial actions taken by the subordinate body, and to see as to whether they are performing their duties correctly or not. So the power of judicial review lies with the Supreme Courts and High Courts.
Is there any provision which talks about judicial review?
Sir, not specifically, but under Article 32, definitely the courts can review matters, and
Directly to
indirectly, yes, sir.
नहीं directly SLP.
SLP, yes, sir, definitely under 136.
Okay. And what about judicial overreach? Is there any instance nowadays?
Yes, sir. I would not exactly say that there are several instances, but definitely we can see there are sometimes we can see that the courts are going beyond their permissible limits, and however I believe that those are also for the beneficial interest of the society only. So one such instance was regarding the COVID times only, when the Supreme Court mandated regarding the ration distribution. Now, these are policy matters. So, policy matters are essentially the domain of legislature, and it is not the function of judiciary to intervene into as to what policy should be made. They are only to
So, will you say this as a judicial review or a judicial overreach?
Sir, I would not exactly, therefore I said I would not exactly call this a judicial overreach. This is judicial activism, indeed, but
वो तो ऐसा है ना, जुडिशियल एक्टिविज्म तो जिसको अच्छा नहीं लगता वो जुडिशियल एक्टिविज्म का वर्ड दे देता है, और जिसके फेवर में है वो जुडिशियल रिव्यू का देता है। तो उससे तो डेट डिपेंड्स अपॉन द डेफिनेशन किस तरह का है। जैसे दवाइयाँ हैं, दवाइयों पर भी इंटरफियर किया सुप्रीम कोर्ट ने,
ऑक्सीजन एंड सप्लाईज
इन रिलेशन टू डिजास्टर मैनेजमेंट कि क्या प्रिंसिपल्स होने चाहिए, किस तरह से मिलना चाहिए। फिर कोविड-19 में इन्होंने उस पर भी किया, जो वैक्सीनेशन लग रहा था उस पर भी डायरेक्शन दिया, सब चीज़ें दिया। तो इट इज़ जुडिशियल रिव्यू है, कुछ भी कर सकता है सुप्रीम कोर्ट एसएलपी में। तो जुडिशियल एक्टिविज्म की डिफिनीशन अब तो गायब हो गई एक तरह।
Sir, I remember there was recently one case where 12 MLAs from Maharashtra Legislative Assembly were completely suspended for the entire 1 year. So this was one case where Supreme Court was kind of criticized that this is the power of speaker there to determine as to whether the suspension or disqualification of legislature members should be done or not. But here the Supreme Court again intervened. So there are instances, but we cannot exactly say that these are judicial overreach or judicial activism. There's a mixed.
All right. Okay, Payal. What do you mean by decree and order? What is the difference between the two?
Sir, decree as provided under section 2, subclause 2 of the Civil Procedure Code says that it is the final adjudication, when any final adjudication of any matter is reached and it has been conclusively determined by the court, from which further no appeal lies, is decree, and it can be preliminary as well as final. Whereas order as defined under section 214, subclause 14, says that it is not, although it is also an adjudication, but this is not the final adjudication, and definitely there are several orders which can be appealed.
Okay. And what are interlocutory orders?
So, interlocutory orders, as provided under Order 39 from Rule 5 onwards, are basically such orders which provides for essentially they are to maintain the status quo of party, so that the property or other things are not destroyed. Such orders are passed.
You can say step in a suit. Different steps are taken.
Yes, sir.
One step is a order, interlocutory order.
Yes, sir.
इंटरलोकेटरी ऑर्डर, अगर ऑर्डर 39 रूल 1 की एप्लीकेशन आती है तो हो गया, या अमेंडमेंट की एप्लीकेशन आती है तो हो गया, इस तरह के
Yes.
इंटरलोकेटरी ऑर्डर.
Sir, I believe Rule 5 is regarding movable property also, that it can order interim sale of such movable property, and under.
By passing such interlocutory order, does it affect any merits of the case?
Sir, these are steps which are taken in between the proceedings, essentially to maintain the status quo and not so that.
What are quasi contracts?
Sir, quasi contracts are those contracts.
तो बता दूं कि इससे मेरिट्स पे कोई असर नहीं होता.
Okay.
इससे मेरिट्स पे कोई असर नहीं होता, इसलिए अगर वो क्वेश्चन पूछते हैं तो बड़ा ब्लंटली जवाब दीजिए कि कोई इससे मेरिट्स पे कोई असर नहीं होता.
Okay, thank you.
चलिए आगे.
Yes.
Sir, quasi contracts are those contracts in which there might not be directly any contract between the two parties, but there are certain obligations due to which a contract automatically develops, which is provided, I believe, under Section 68, from Section 68 to 72 of the Indian Contract Act. For example, Section 68 talks about whenever any necessities are provided to minors. So there, when such necessities are provided, so there a relation of quasi contract generates, and the minor, through the estates of his property, is bound to compensate the one who has provided for such necessities.
Compensate or reimburse?
Reimburse, sorry, sir. Reimburse.
All right. Sir, any other question?
ठीक है. General, you have got good personality test.
Okay, Payal, one more question I want to ask. That who is the current Chief Justice of your High Court?
Sir, it is Honorable Mr. Ravi Ranjan, Justice Mr. Ravi Ranjan.
Justice Ravi Ranjan.
Yes.
And who is the Governor?
It is Mr. Ramesh Bass.
Okay. And कौन सी अभी गवर्नमेंट है आपके उधर?
Sir, it is Jharkhand Mukti Morcha.
झारखंड मुक्ति मोर्चा. और ऑपोजिशन में कौन है?
Sir, I believe BJP है, sir.
Alright. And who is the candidate in opposition for CM?
Sir, opposition में श्री रघुवर दास जी.
And who is the current Chief Minister?
श्री हेमंत सोरेन जी.
आज है मैं सुना.
And who was the former Chief Minister of Bihar?
Sir, श्री रघुवर दास जी.
Okay. Why Mr. Lalu Prasad is still in news?
Sir, this was regarding the fodder scam case, and the final judgment regarding the biggest scam recently came, I believe, last month only, in which he was again convicted.
Okay. What you have to say about the Ukraine nowadays? What is happening in Ukraine?
So the dispute between Ukraine and Russia majorly pertains to the NATO membership. So the concern here was that Russia never wanted NATO members to move more towards east and establish their bases in Ukraine. So because already there was breach of certain treaties after the Cold War, when the Soviet disoriented, then there were certain treaties in which there was said that no nuclear weapons should be made and all should be destroyed.
All right.
So, yes.
Okay. Okay, Payal. So
थैंक यू. बहुत अच्छा, बढ़िया.
everything was fine. Later I will be telling that where you should improve yourself, right?
Thank you so much. Thank you.